Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Yoink. I still have not put my laundry away. That's horrific. I should have done that. Two things. One, we're going to answer a question, but before we do that, tomorrow, May the 17th of 2024, we are doing a live question and answer with an employment attorney beginning at 5 p.m. Eastern Time and going for at least 1 hour. Also, quick announcement. So a buddy of mine has a business teaching piano, and we're going to do a quick collaboration talking about that, talking about, him as an employer, his life as an employer, and, his business and stuff like that. It's not the most on topic for the channel, but he's great, and I think some of you might enjoy his content, so I want to bring him on. Our question today is from YouTube user Tech5280, and Tech5280 asked us, excuse me, on average, how much does it cost a company to defend discrimination and retaliation cases from the EEOC process all the way through federal court? So it does vary wildly, right? If your employer hires a budget firm like a Jackson Lewis, which is, generally going to be a cheaper way of defending these cases, then it can be a lot cheaper. I mean, they might land the ship for a prospective employer somewhere between $50,000 and $100,000. That's how cheap they can be as a budget option. If you hire more premium options, $1,600 an hour, stuff like that, sometimes even more. You could easily be looking at a bill for the employer between $100,000 and $300,000. I've had conversations with defense counsel where at mediation, like a late mediation, like we're all the way through discovery, maybe a summary judgment motion is pending, we're at mediation and trial's coming up, and the attorney will say, like, listen, if you don't settle this case, I'll do something for my client. And this is like a threat in his mind, I'll flat rate the trial for $80,000. They can pay for the entire trial for a flat rate of $80,000. And in their mind, that's like how cheap I'm going to do this trial for my client so they don't have to settle with you. So you should take the deal that's on offer right now, because I'm going to do this trial so cheap that they don't have to offer you anymore. Of course, that's not what I hear. What I hear is your client's already in at least $100,000, and probably more, given the fact that you think flat rating a trial for $80,000, trial prep and trial presentation, is a good deal. So what I'm hearing is, whatever's on offer now, we can just go ahead and tack 80 on that, and let's see what that does for my client. Let's talk about that. That's a different conversation. Maybe $80,000 more moves the needle. I don't know. Let's go find out from my client, right? Now, Tech5280, part of why people ask this question a lot, and I don't know if it's why you ask this question, but part of why people ask this question, because they think that concept of like, oh, well, it's going to cost them $300,000 or $200,000 or even $100,000, or it's Jackson Lewis and it costs $50,000, whatever it is. So that's the minimum my case could be worth, because that's what it costs. That logic does not always work, because often employers feel the need to fight a case and spend the extra money to make a point, to keep other people from bringing cases, right? If everybody knows that it costs you $300,000 to defend a case, and so you always give out $300,000 in settlement, guess what? Every employee you let go will bring a case against you. That's just how that goes. So employers get stuck fighting when they don't even want to sometimes, right? Sometimes they'd rather cut a check, but they've got to fight the case because they think if they don't fight the case, it's going to set a tone with their staff, and everybody's going to sue them every time they get fired. So you get into these tough situations where employers will fight things out even though they don't want to. But yeah, that's a rough idea. There's no average, because different firms are different. Different areas of the country are different. Different employers have different amounts of documentation. Different HR departments do things differently. If an HR department really keeps everything kind of tight for the defense counsel, the billing goes way down because the defense counsel has a lot less to do. Certain companies have in-house situations where they respond to discovery demands, right? Like they have the ability to automate the running of their servers in a way that is responsive to discovery demands. Like we have run into that. And that's something they do both for efficiency, because perhaps they get sued a lot and they need to have that efficient means of responding. It's also something they do to bury plaintiff side counsel in huge numbers of documents, right? A lot of times, whether they're doing that in-house or whether they're using a vendor to do that, right? There's vendors that will help companies respond to discovery demands that are much cheaper than having the defense counsel do it. When they're doing that, often what they're going to try to do is bury the plaintiff side counsel under 600,000 documents or more, right? I think like I've seen cases with like 2 million documents. And part of that plan is to hit plaintiff's counsel with an unmanageable amount of discovery so that it can hide the important discovery items in that unmanageable amount. Now, there's things plaintiff's counsel can do, like, fighting about the format and getting everything word searchable. And plaintiff's counsel will sometimes have to hire deposition coding or discovery review houses to come in and go over things. And, because there's no plaintiff firm, generally speaking, with enough attorneys to go through 2 million documents in a month. Like that's a lot. That really adds up. So you do end up needing to fight vendors with vendors, right? Like if an employer brings in a vendor to do a discovery dump like that, and they're doing it very cheaply, the plaintiff side counsel may need to then go pay for a vendor to, or whoever. It depends on your retainer, right? Maybe you're paying. Like if you're covering the expenses and your attorney's not, like our firm, we cover the expenses. So if we're like, hey, we need a vendor to do like deposition coding, or we need a vendor to do forensic IT, or we need a vendor to thumb through this last million documents on this discovery production, because we got everything we think we want, but we want to make sure there's nothing hiding in the rest. We just pay for that. But that's not the arrangement with every firm. Some firms are going to come to you with their hand out and be like, hey, they dumped 2 million documents on us and we need cash money up front to hire a vendor to go through that. So just, that's one of the issues with expenses. It's also worth noting, listen, there's companies, IBM springs to mind, that have moved a lot of their employment defense work in-house. And that's very rare, but it does happen. Usually those are companies that are being sued at such a constant volume that it's no longer cost efficient for them to hire big law defense firms, right? They need instead to hire people in-house because the volume of cases being brought against that company is so high and so constant and consistent that they just set up an employment defense department, right? I mean, that is somewhat rare, but it happens, and that will drastically adjust downward the cost of defense because they're going to have those attorneys on the clock on salary anyways, right? This is one of the issues with suing state and municipal bodies. They've already got the attorneys. They don't pay the attorneys more because you sue them. They just assign it to their teams of attorneys, and the teams of attorneys will figure it out. They'll work more if they have to or whatever it is, but like they're probably not going to have to staff up to deal with your case. That's often something that causes cases against state municipal bodies to take longer. One, because the attorney's overwhelmed because they don't get staffed up when additional cases come in, but two, because they already have the attorneys and they're not paying for the attorneys. So there's no impetus, there's no outside force being like, hey, you are throwing money down this hole, so maybe just settle the case, right? Like big attorney's fees do push settlement, to your point, Tech 5280, which I assume might be what you're bringing up here. Also, I mean, state and municipal cases take longer because their money's not at risk, right? It's your money, it's tax money, so they're like, what do we care if you win a big result? It's not our money, it's taxpayer money. We don't care about taxpayers, right? Like that's part of what takes longer with those cases. But it really is also that they have their attorneys already, and that can happen in IBM, in-house defense teams for private companies. That can happen to a lesser extent, but it can happen. Anyways, Tech 5280. I hope this helps. If it did, like, subscribe, comment down below, share the channel so it may grow. I have now fulfilled my obligations for the day, and I wish you well. See you all for the live stream tomorrow, 5 p.m. Eastern Time.